Good afternoon, ladies and gentlemen. My name is Tom Becker. I serve as the president of Chautauqua Institution, and it is my great pleasure to welcome you to this absolutely magnificent facility. This is a very happy day every year in the history and the program of Chautauqua. This is where we overtly exercise a cooperation that runs very deep between this institution and the Robert H. Jackson Center. Now, the center is located in Jamestown. If you haven't been there yet, you really ought to take the 15-minute trip to go down to the center. It's a repository of some really solid history about America and about a particular American in his place in history, which has been so incredibly significant. That center's creation obviously focused on the fact that Justice Jackson was from Jamestown, was really generated by the passion and energy of two human beings. Greg Peterson, an attorney in the local area whose passions extend to, let's say, baseball. Well, no, we won't go into them all. But in any case, his remarkable passion for the development of this center, along with a predecessor of mine, Dan Bratton, who spent 16 years as president of Chautauqua Institution and faced retirement to become the executive director, president of the Robert H. Jackson Center, a job that he was relishing. And unfortunately, pancreatic cancer came between he and that objective. There is a certain poetic circle to the fact that Adam Bratton is the current executive director of the Jackson Center, and I find great joy in that fact. Adam's in the back of the room over there. You might recognize Dan's profile, though he's better looking than Dan was. This afternoon's program, as the partnership that I just indicated, is really the fifth of these lectures we've given in the last 5 years. We've covered subjects in legal, justice, and academic circles. In just a moment, you're going to hear from John Q. Barrett. John is an extraordinary historian and, frankly, narrator of American history. He's also a specialist in areas of the law, and within that, he has a remarkable history with Robert H. Jackson. If any of you are on his email blast site, you know that as the court makes a decision or as someone from Congress refers to Jackson and carries some quote, John quickly corrects all of that, puts it in the proper perspective, and says, no, this is what he was really talking about. He is a fabulous narrator and interpreter of Justice Jackson. He's also the editor of That Man, which is an insider's portrait of Franklin D. Roosevelt that Justice Jackson had written but had not published. And so John's work along those lines is also a very important contribution to American history and to understanding Roosevelt from the point of view of Justice Jackson, who, as you know, in addition to being a Supreme Court justice, was also the American prosecutor of the Nuremberg trials. That history is deep and rich, and John evokes all of it with both scholarship and a real narrative talent. Ladies and gentlemen, John Q. Barrett.
Thank you very much, Tom and friends. It's always a real personal pleasure and a great privilege to speak at Chautauqua. It's a particular privilege to get to introduce what is becoming a fine and, as President Becker notes, collaborative tradition of a Robert H. Jackson lecture here at Chautauqua each summer on the Supreme Court of the United States. My modest role this afternoon is to say a word about Jackson, a word about the Supreme Court, and a word about this year's Jackson lecturer. Robert Jackson, as Tom Becker noted, is a local product, but he went from this soil and this region on a very high trajectory. It included a 20-year career in private law practice and then nearly a decade in government service before he went to Nuremberg. His government service in Washington under President Franklin Roosevelt included a stint in the Treasury Department and then service up through a ladder of positions in the Justice Department, culminating in service for 2+ years as the Solicitor General of the United States and then as the Attorney General of the United States before Jackson was appointed to the Supreme Court in 1941. In 1945, he took a 1-year leave from the court on appointment from President Truman to serve as the architect of, and then as the chief American prosecutor at, the International Military Tribunal, before which the senior Nazi war criminals were prosecuted. And a proceeding that built the historical record that allows us to know the crimes, the conduct, the Holocaust that was Nazism. Jackson returned to the Supreme Court after Nuremberg and lived and served for 8 more years. He is revered across the legal profession, in law studies, in American history, and internationally for his life and his contributions and his sparkling writing and advocacy. And that significance is, frankly, a growing industry. I, as a biographer, play a role in that and get to benefit from it. And Chautauqua Institution, as one of his core roots and formative locales and identities, is a big part of that. Part 2, the Supreme Court of the United States. Of course, from Article 3 of our Constitution, across the centuries of our country's existence, and in the year that is every year, and in the lives that is every person, the Supreme Court is enormously significant. The Supreme Court, particularly on its calendar, beginning a term in October and rising for a summer recess in June, situates itself very conveniently for the Chautauqua Institution program, and for a venue like this as an opportunity to focus on the court. It's probably not planned exactly that way, but it works out quite beautifully. Here you are, here we are, and here we have lecturers like the one I'm about to introduce to help us focus on the court at an annual moment to take stock and study where we are. Of course, this year, particularly, the Supreme Court is on our minds, and literally this day on our eyes, as the Senate began its hearings on the confirmation of President Obama's nomination of Judge Sonia Sotomayor to fill the vacancy created by Justice David Souter's retirement. So we have the end of a term and a Sotomayor summer, or a hearing that will take less than a summer, that focuses us on the Supreme Court. Part 3. The Jackson Lecture at Chautauqua Institution on the Supreme Court of the United States. This tradition began in 2005, and every year, frankly, it has grown in greatness, the greatness of the audience, the interest, the questions, the scrutiny, the reflection, and the stature of the lecturers who stand on each other's shoulders and are building a fine tradition here. Professor Jeffrey Stone of the University of Chicago Law School inaugurated this lecture in 2005. He was followed in 2006 by Seth Waxman, a former Solicitor General of the United States under President Clinton, now an attorney practicing with the national and international law firm of WilmerHale. He was followed by Linda Greenhouse in 2007, then the New York Times Supreme Court correspondent and now a professor at Yale Law School. And she was followed last year by Jeffrey Toobin of the New Yorker magazine and CNN. Those 4 lecturers are now succeeded this year by Paul Clement. Paul Clement is a native of my native Wisconsin, so he's my brother from the soil. He has a distinguished resume, a life of achievements, honors degrees from Georgetown University, from Cambridge University, from Harvard Law School. He then served as a law clerk, first to Judge Lawrence Silberman, a distinguished judge of the D.C. Circuit Court of Appeals, and then to Supreme Court Justice Antonin Scalia. Paul's career then climbed higher. He had a stint in private practice, service as a counsel on a United States Senate committee, and then a stint in the U.S. Department of Justice, first as a member in the office of the Solicitor General of the United States as a deputy, and then from 2005 until 2008, he was the Solicitor General of the United States. In that role, in that office, he was part of representing the United States, both the executive branch and the statutes, and behind them, all of us, in the appellate courts of our country, and culminating in the top of the pyramid at the Supreme Court of the United States. Paul has argued before the Supreme Court, I believe, 49 times. And he has a couple of cases coming this fall, and he soon will pass Justice Jackson's number, which is in the 50s. He is a sterling advocate. You'll see his forensic skills in a moment. He is a legal talent who is appreciated across all spectrums. His stewardship in the Department of Justice as Solicitor General is regarded across all spectrums as one of the fine pieces of public service in our country's recent history. I'll note that Solicitor Generals have a tradition here at Chautauqua. Paul becomes, by my count, the 5th former or future Solicitor General to speak from a Chautauqua audience to a from a Chautauqua platform to a Chautauqua audience. Robert Jackson, of course, was one. He was SG 1938 through 1940. Thurgood Marshall in 1957 was still not yet the Solicitor General, which he became in the 1960s, but he spoke at Chautauqua. Stanley Reed, who was Franklin Roosevelt's Solicitor General before Jackson, spoke at Chautauqua in 1937. That was the summer of the court packing plan. And as I mentioned, Seth Waxman in 2006 spoke here as a Jackson lecturer in this series. I'll note one final pairing that I think makes this a wonderful opportunity and illustrates something about the legal profession, the Supreme Court, Solicitors General, and the rule of law. You may recall, if you were here, that Mr. Waxman spoke about the run of Supreme Court cases in the War on Terror when he was here in 2006. And other aspects of Supreme Court work were also his topic. But in a sense, he previewed then the argument that he would give later that year in a Guantanamo case involving federal statutory and constitutional rights to habeas corpus review for the detainees imprisoned by our government at Guantanamo. That case was called Boumediene versus United States. And it was decided the following June, and Mr. Waxman and his client were the prevailing parties in that case by a vote of 5-4. I mean this not at all to poke. Paul Clement was the losing attorney in that case. Boumediene versus the United States was Seth Waxman as a private pro bono attorney representing Boumediene against the United States. And Paul Clement was our lawyer. He represented the United States. He took the path of law, of public responsibility, of tradition, precedent, and principled argument to the right place. He defended in proper terms the position of the executive branch to which he had been confirmed by the Senate, in which office he held at that time. And he made arguments that I encourage you to listen to on Foyer.com, where you can hear his Supreme Court advocacy generally, and he lost. And something like that is a piece of the greatness of the United States. We are a nation of the rule of law. We are a nation of the Constitution. We are a nation of public courts and legal accountability. And it turns on the commitment that we as citizens and our greatest advocates as lawyers have to that system. Robert Jackson was a piece of it. The Supreme Court is an enormous piece of it. This lecture considers and celebrates a piece of it, and Paul Clement is a very important piece of it. And so it's a privilege to welcome him today. Thanks.
Well, thank you, John, for that wonderful introduction. It is wonderful to be here. I have to say this is just a very special place, so I'm very happy to be with you. I wanted to start with a bit of a story, and the story is, I think, useful because it illustrates the incredibly high regard that Justice Jackson is held by almost everyone in the Justice Department, and this is true, of course, across administrations, whether it's a Democratic or a Republican administration. There's a tradition in the Justice Department that the portraits, the formal portraits of former attorneys general will adorn the walls of high-ranking officials within the Justice Department. And of course, as with most things, seniority matters. So the Attorney General gets his or her pick of the portraits, and the Deputy Attorney General, the Associate Attorney General, the Solicitor General, now the fourth-ranking officer in the department. When Jackson served, it was the second-ranking position, and so on down the line. There's another tradition, which is sort of less august, which is the cabinet members, if they so choose, can have access to artwork that is not hanging on the walls of the National Gallery, but is part of the extensive collection. Well, the first Attorney General under which I served, John Ashcroft, exercised in this regard what I think was good judgment, which is rather than fill his office with portraits of former attorneys general, who, as even he pointed out, were not men selected for their good looks, he chose artwork from the permanent collection of the National Gallery. And so that had the effect of allowing more subordinate officials within the Justice Department to have portraits of some of the real star attorneys general. And in that process, we were privileged in the Solicitor General's office to have the portrait of Robert Jackson hang in our anteroom, and as one of only two former Solicitors General who went on to be an Attorney General, and the only one of that pair that served on the Supreme Court, it seemed perfectly fitting that he would adorn our wall. And then when General Gonzalez took over from General Ashcroft, he decided that he was not as enamored of the National Gallery works and thought he would collect some of the portraits of former attorneys general into his office. And of course, right at the top of that list was Justice Jackson. And the only other portrait that was actually in the SG's office at that time was a portrait of William Frank Smith, President Reagan's first Attorney General, that my predecessor as Solicitor General, Ted Olson, very much wanted in his personal office. As it turned out, the Attorney General Gonzalez, wanted both the portraits that were in the SG's office for his office. Now, I made a very strategic decision early in this process and said, I'm going to let him have Smith. I'm going to try to make a play for Jackson. Smith was very important to my friend and mentor Ted Olson, not so much to me. Plus, I did have my eye on Judge Bell's portrait, since he was a former senior partner of mine in private practice. So I sort of had the personal office portrait covered, so I thought. So I had to figure out, though, how does one make an argument to keep the Jackson portrait when there's a very simple organizational chart at the Justice Department and the Attorney General is very much on the top of it. But I was good friends with the Attorney General's Chief of Staff, and I talked to him and I said, of course, I understand the org chart, I understand the rules, and we're happy to give you both portraits. But of course, I would like to just make a ploy, make some kind of opportunity to if we could possibly keep the Jackson portrait, because as a former Solicitor General, it's really important, I think, to the esprit de corps of the office, and it would just be a wonderful thing. And lo and behold, the advocacy, I guess, is occasionally rewarded. The Attorney General relented, and the Jackson portrait stayed in the SG's office. And just as I was about to exhale, I got a call from the Deputy Attorney General, Jim Comey. And of course, he too had lost a couple of portraits to the Attorney General in this process. And when he found out that Jackson wasn't going to the Attorney General's office, of course he thought, this is great, I'll go get the Jackson portrait from the SG. So here I was, and I didn't have a Smith portrait to trade at this point either. But I knew Jim Comey. Jim Comey was a good friend of mine. We worked very closely together. And I knew that Jim was somebody who cared very much about the esprit de corps of the career lawyers in the department. So I modified my argument only slightly and made the point to Jim that it would really, of course, I understand the org chart, would be happy to send Justice Jackson's portrait along, but it would really be important to the folks in the office if we could keep him. And I knew my man. Jim relented in a heartbeat, and we also got to keep the portrait there. I was about to exhale again when the Associate Attorney General made a ploy both for Jackson and for Judge Bell's portrait, at which point I rehearsed my lines on Justice Jackson, and then and that worked. And then as to Judge Bell's portrait, the Associate Attorney General was a great lawyer named Robert McCallum, who was a partner at another prominent Atlanta law firm, Alston and Bird. And I told Robert, obviously if we could keep the Jackson portrait, that'd be great. The Bell portrait is yours. I'll just have to content myself with telling my former partners at King & Spalding that the judge is now hanging in an Alston and Bird lawyer's office. And instantaneously said, no, you keep him. You keep him. So this shows both advocacy within the executive branch, but the reason I tell you this long story is because it just shows the reverence with which Justice Jackson, Attorney General Jackson, Solicitor General Jackson was withheld by all the senior lawyers in the Justice Department. And this is in a Republican administration, and Justice Jackson, after all, was FDR's Attorney General. So that in and of itself tells you something about the strength of the views that people have about what a wonderful servant of justice Justice Jackson was. I'm going to return in a minute to just a few thoughts about why it is that Justice Jackson is held in such high regard and is held in such high regard in the Justice Department. But let me talk for a few minutes first about the Supreme Court, which is, after all, the topic of the Jackson lecture. But let me talk about it in terms of one of the very important relationships, I think, that the Supreme Court has. And it's a relationship that was quite important to Robert Jackson. And that's the relationship between the Solicitor General, and more broadly the Office of the Solicitor General, and the United States Supreme Court. Now, Justice Jackson was privileged to have very close relationships with some of the members of the Supreme Court that he argued in front of while he was Solicitor General. Justice Reed was his immediate predecessor as Solicitor General and a very good friend. Chief Justice Hughes was also somebody who was a personal friend of Justice Jackson and somebody for whom Justice Jackson had the highest regard. There were times when there were tricky issues between the office and the court in which Justice Jackson, then General Jackson, was able to take advantage of this personal relationship. But I think over time, the extent to which the Solicitor General had a personal relationship with various of the justices has varied. But what has never varied is the fact that there has always been a special relationship between the office and the Supreme Court. The relationship is so close that the Solicitor General is often referred to as the 10th Justice. Now, I'm quick to add that I've never heard any of the 9 real justices refer to the Solicitor General as the 10th Justice. And one of my illustrious predecessors, Drew Days, I think probably got it closer to the truth when he referred to the Solicitor General as the 35th law clerk. But whether it's the 10th Justice or the 35th law clerk, there is this incredibly close relationship between the office and the Supreme Court. And I'd like to talk for just a few minutes about why there is this special relationship. Where does this come from? And I think to understand this relationship, you really need to get a brief understanding of the work that the Office of Solicitor General does, administration in, administration out. And I think you start, obviously, with maybe the one thing that people, if they know anything about the Solicitor General's office, would know, and that is that the Solicitor General argues cases for the executive branch before the Supreme Court of the United States. So that's the one thing that maybe somebody would know about the role of the Solicitor General. And that is a defining feature of the work of the office. When Justice Jackson was Solicitor General, he took that responsibility very seriously, arguing 24 cases in one term by one report, which is an enormous number of cases. So that is a very important part of the work of the office. It's why many people are attracted to the office in the first instance, since it's a great high privilege to argue a case in the Supreme Court, win or lose, as John points out, on behalf of the United States of America. That is a high privilege and a great honor. It is also just the tip of the iceberg of the work of the office. And in some respects, the rest of the iceberg is more important for understanding really the function of the office, but also the source of this special relationship. The office also plays a tremendous role in deciding which government cases that have been lost in the Court of Appeals the government will try to take up to the Supreme Court and have them reviewed. As you may know, the Supreme Court has discretionary review, something that most courts with mandatory review surely envy. They only have to take cases that they want to take. There's a process for deciding which cases they'll take called the certiorari process. Each year there's over 7,000 petitions for certiorari, dissatisfied litigants asking the Supreme Court to review their case. Of those 7,000 cases, the Supreme Court only takes about 70. So literally you have about a 1% chance of the Supreme Court hearing your case on the merits. Now, for most clients, if they're dissatisfied with a result in the Court of Appeals, they have no difficulty getting a lawyer to file a cert petition and try to take their case up to the Supreme Court of the United States. The lawyers within the executive branch of the United States are, at least at first blush, not so lucky. They can't simply call up the Solicitor General and demand that he or she file a petition for certiorari. The best they can do is recommend that that course happen. When that recommendation comes through, the Solicitor General initiates a process that involves a review of all the potentially affected parts of the federal government, that also gets involved and solicits the views from various parts of the Justice Department, that involves an independent review by a lawyer in the SG's office, a subsequent independent review by one of the 4 deputies in the SG's office. Ultimately, a large packet comes across the Solicitor General's desk. There may be a number of meetings to figure out whether the office will file the petition, and a judgment is ultimately made whether to file the petition. In the overwhelming majority of cases, even though there was an adverse result and the lawyers principally affected want to take the case to the Supreme Court, the Office of the Solicitor General will say, no, we're not going to take it up. Now, this shows ultimately in the results in those cases where the office does take a case to the Supreme Court. As I said a minute ago, the average cert petition has a 1% chance of being granted. The Solicitor General's petitions, administration in, administration out, get granted about 70% of the time. Now, why is there that enormous difference? It's not because, and the special relationship is not one of deference or anything of the sort. It's because the Solicitor General's office is essentially making a cut of its own. It's looking at the Supreme Court's own criteria for taking cases, applying those criteria, and then basically saying, we're only going to take cases in the main that fit those criteria. And I think where this practice really bears its fruit is in those cases that are a little bit at the margin. They may not seem obvious to the court that they're important, but they know that if the cases survive the Solicitor General's own process, that's likely to be a case that the Supreme Court should at least give serious consideration to. Just a great example of this is one of the last petitions I filed before I left office a year ago. It was a case involving the anti-dumping trade laws. Sounds a little dull. Actually, it wasn't so dull because the particular duty at issue in this case, the countervailing duty, involved the duty on uranium imports from France. And the result of the lower court decision was to make uranium from France very cheap. There's a problem with that is that the United States had an ongoing program with the former Soviet Union to try to take weapons-grade uranium and downgrade it to commercial-grade uranium. That's an expensive process. And it was only commercially feasible if the competing uranium, principally from France, was also relatively expensive. Without this duty, the French uranium would flood the market, and this whole process of getting rid of weapons-grade uranium would be frustrating. When we filed the cert petition, not only were we able to tell the Supreme Court all of that background, but we were also able to tell the Supreme Court that this was the first time the Solicitor General's office, in the history of the 25-year history or whatever it was of the anti-dumping statute, was the first time we'd ever asked the Supreme Court to hear one of these trade cases. And I think that's the kind of restraint that can be exercised in this process that builds that kind of special relationship. The court, for what it's worth, took the case and reversed the lower court 9-0. So that is a good illustration of the process, I think. Now, somewhat remarkably, I think, given the amount of man and woman power that's expended in the process, the Solicitor General's office goes through the same process, essentially, whenever the United States loses a case in the trial court and a lawyer wants to take it up just to the Court of Appeals. So we're not talking about the rarefied air of the Supreme Court. We're talking about Court of Appeals where the appellate jurisdiction is mandatory. Anybody can appeal any case. The Court of Appeals has to take it. But the office goes through this incredible process again. A major part of that process, a major reason for that enormous process that the office goes through 2,000 times a year, is to make sure that the United States is not taking positions in the Court of Appeals that they could not defend in the Supreme Court of the United States. Another big part of the day-to-day work of the office comes in resisting petitions for certiorari that are filed by the other side in litigation. I don't want to leave you in talking about the process of approving appeals and cert petitions with the impression that the federal government only loses cases in the Court of Appeals. They win the vast majority of their cases. In fact, if you go back to that 7,000 cert petitions that the Supreme Court hears every year, fully half of those, 3,500, are cases where the federal government is the prevailing party below. So a process for deciding whether or not to file a brief in opposition has to be gone through. About 90% of those cases, the United States actually waives its opportunity to file a brief in opposition. That still leaves 350 briefs to be written every year. So that's one a day, and that's work in the cert process, not merits work. So not the most glamorous work that you can imagine, but very important work nonetheless. The last thing I want to talk about in terms of this process is the process that's involved in deciding whether to participate as an amicus. There are 2 points where the United States has to go through this process. One is when a case involving private parties has been granted and the United States was not previously a party. At that point, the United States has to go through a process of deciding whether to participate in the case and on what side to participate in the case. The Solicitor General spearheads that process. But the other juncture at which you can file an amicus brief is before the Supreme Court has even taken the case for review on the merits. So these 7,000 petitions, if you want to, you can file an amicus brief urging the court to take or not to take the case on the merits. Lots of private parties file briefs, friends of the court briefs at this stage. The United States of America in the SG's office almost never does. One of the reasons they almost never file these briefs is because of this special relationship, which is manifested in a very real way, which is about 20 times a year in a cert petition in a case that the United States has not previously participated in at all. The United States Supreme Court will issue an order inviting the views of the Solicitor General on the case. Now, two things are noteworthy about this. First, this is the classic invitation one cannot refuse. The court invites the views of the Solicitor General. That's very nice, that's very polite, but of course, a response is expected and is essentially mandatory. But second, I think in some respects more importantly, the court does not invite the views of anyone else. There are other situations where it might be interesting to know what the state attorney general of the state thinks about an issue. You might have an international law issue where it would be very interesting to know what the views of the European community are. But the court doesn't invite views in those situations. The only views it invites are those of the Solicitor General. And as I say, it goes through this process about 20 times a year. So I think that in trying to locate and understand this special relationship, it is really one, I think, that is a product of the constant interaction that the Solicitor General's office has with the Supreme Court of the United States. And it is respect and a special relationship that is earned by doing things such as applying the court's own criteria and not wasting the court's time with cert petitions that are not serious and meritorious petitions for certiorari. It's also something where I think that you are constantly interacting with the court in a way that even if you didn't, as I think every Solicitor General has, hold the court in the highest respect and treasure the relationship that the office has with the court, I still think if you just had self-interest in mind, you would also continue the special relationship. Because when you're litigating in front of the court all of the time, you can't take the opportunity to advance your cause in one case and have the court question your credibility or your candor, because it would come at the expense of your position in all those other cases. Supreme Court hears about 70 cases a term. The Solicitor General's office represents the United States as a party or an amicus in about 55 of those cases. So in virtually every case, the United States is there, and the long-term interests of the United States are best served by maintaining the special relationship. Just one further thought on this constant interaction. It's interesting in Justice Jackson's own career that when an opening on the Supreme Court that was created, essentially ultimately two openings that were created by the resignation of Chief Justice Hughes. Chief Justice Hughes talked to President Roosevelt and put in a very strong endorsement of Justice Jackson as an associate justice, not to replace him as Chief Justice, but as an associate justice. And he did so based on the wonderful job that Justice Jackson had done as Solicitor General. Now, Justice Jackson had been Attorney General for a couple of years after that, but it wasn't his role as Attorney General where the truth is the court probably wasn't watching him and seeing him in action on any kind of day-to-day basis. It was Justice Jackson's work as Solicitor General Jackson that caused the retiring Chief Justice to endorse him. Now, I wanted to say one other thing about Justice Jackson before turning to making a few observations about the Roberts Court. And I want to focus in on the very point in time when Justice Jackson is leaving the Solicitor General's office and becomes Attorney General of the United States. Now, by any stretch of the imagination, this is a promotion. The organizational chart says so, and Justice Jackson, I think himself, was interested in becoming Attorney General. But notwithstanding that, upon some time of reflection, when Justice Jackson looks back at this, he noted at the time of this juncture of time, when he finished his service as SG and took up the reins as Attorney General, he said, quote, "I stepped out of the office in the executive branch of the government that I enjoyed most and into a sea of trouble." And that is a very interesting description of a cabinet position, a sea of troubles. Now, one aspect of this, I think, that comes clear is that Jackson was first and foremost a lawyer. And as he himself described the Solicitor General's job, it's a lawyer's job. The SG's duty was, quote, with the law, not policy. And the Attorney General's job cannot be described that way. It is certainly a law enforcement job. There are certainly legal issues. But whereas the Solicitor General gets to focus on a day-to-day basis on essentially legal issues that are prime and ripe for litigation, the Attorney General has to deal with a whole host of issues, including issues that aren't in litigation, but very difficult issues about counseling the rest of the executive branch as to what's lawful conduct. And as both Justice Jackson's tenure and recent events well illustrate, that job, which is never easy, becomes very, very difficult during a time of war. And I think there's a great illustration of the kind of pulls that lawyers in this position are under and the kind of difficult decisions they face from Justice Jackson's tenure. And the specific illustration I'd like to point to is the question over the legality of the Lend-Lease arrangement with Great Britain. So as most of you know better than me, at that point at the beginning of World War II, before the United States got involved, President Roosevelt very much wanted to lend some destroyers and other war material to Great Britain. And a very serious question came up within the executive branch as to whether or not this transaction with Great Britain was lawful under the then extant statutory framework. Now, there were really three views of this matter. There was a very strong chorus of views that said that without some authorization from Congress, this Lend-Lease maneuver was illegal and could not be done. There was an equally strongly held view that the president could do this under the statutes as it then existed, and there was no need for further congressional authorization. Justice Jackson, as Attorney General, found himself in the middle. He was very much of the view that this transaction could take place without congressional authorization, if, but only if, there was an exchange, a quid pro quo. The way he read the statute, which dated from the last war in 1917, the way that Attorney General Jackson read the statute, the only way it was legal is if there was this quid pro quo. Now, this created some diplomatic problems for no less a personage than Winston Churchill. Because Churchill did not want a quid pro quo. He wanted the United States to make a gratuitous, invaluable gesture to Great Britain to show that the United States was with them. Churchill didn't want some trade that you might make with any nation. He wanted this gift from the United States. Now, as I understand the story, this became a topic of discussion between FDR and Churchill. And FDR told Churchill, quote, "The trouble I have is that I have an Attorney General, and he says I've got to make a bargain." Churchill apparently replied, "Maybe you ought to trade these destroyers for a new Attorney General." Now, standing firm in your legal views in the face of no less an authority than Winston Churchill is a very, very difficult task. Jackson, thank God, was up to the task, and as it happened, the Lend-Lease arrangement was ultimately arranged as an exchange, and Jackson gave an opinion where he gave his blessings and the Justice Department's blessings on the legality of the exchange. Now, just to complete the circle here, notwithstanding the fact that Jackson's opinion didn't make Churchill happy, it also didn't make all manner of political opponents or even objective legal scholars particularly happy either. And so, a contemporaneous commentary of a very well-respected presidential historian, Professor Edward Corwin, he wrote, in describing Jackson's opinion, upholding the legality of the transfer, he said, quote, "The opinion is thus an endorsement of unrestrained autocracy in the field of foreign relations. No such dangerous opinion was ever before penned by an Attorney General of the United States." So I think that it is a good illustration of just how difficult it can be, just what a sea of troubles it can be to be advising and counseling the President of the United States during wartime. Now, Jackson survived this sea of troubles. And not only did he survive this sea of troubles, but he went on to great service in the Supreme Court of the United States. And he went on to great service as a Nuremberg prosecutor. And today, many years later, he's held in such high regard within the Justice Department that political appointees tussle over the location of his portrait. Now, you can ask very, I think, honestly and sincerely, what's the answer to either the extreme interest in his portrait or his enduring legacy? And much could be written about this. I think John's working on a book that will be dedicated, at least in part, to this topic. But I think what I would offer you is my own perspective on this, is that Justice Jackson had a theory. He had a theory of how to be Attorney General. He had a theory of what the role of the nation's highest law enforcement officer was. It was not a theory that everybody would subscribe to. It was not a theory that said that you just have to apply a completely independent view of the law no matter what, and you don't have to essentially give the benefit of the doubt to the president. That was not his theory. But he had a rigorous theory. And whether you agreed with it or not, the theory was evident. One could criticize him on that theoretical ground. And it's equally true that whether you agreed with his theory or not, it was very hard to quibble with the man that he was true to his theory. And so you might not have liked the advice he gave in one particular or another, but I think you could see that there was a coherent thread that involved great respect for justice, great respect for the rule of law. And I think because of that, he held a tremendous respect and esteem of the lawyers in the Justice Department at that time and ever since. Well, let me finish by shifting gears for a few minutes and talk not about the Sea of Troubles, not about the Solicitor General's role, but about the Supreme Court of the United States. And not just any Supreme Court of the United States, but the Roberts Court. Now, let me start with a caveat. I think it's difficult to say too much about what we know about the Roberts Court, because the Roberts Court, in any kind of historical view, after all, is relatively new. The Roberts Court has had only 3 full terms with its current membership. To make matters more difficult, the membership is changing, and it's hard to not be cognizant of that on this day as the hearings for Judge Sotomayor to become Justice Sotomayor are taking place in Washington. And of course, that change in personnel will itself have a change on the dynamic of the court. The old adage in Washington is, if you change one member of the Supreme Court, you have an entirely new court, not just one new member. And I think that's proven true. And in that respect, I think we, watchers of the Supreme Court, were a little bit spoiled by what is often referred to as the late Rehnquist Court. Because there was a period of 12 years, the second longest period in history, where the membership of the Supreme Court did not change at all. So you could really talk about the Rehnquist Court, or at least the late Rehnquist Court, and really understand at least which 9 individuals we're talking about. The Roberts Court is going through a transition, and of course the first year that Justice Roberts was on the court, for most of that term, Justice Alito had not yet taken a seat until February of that first term. So there are some difficulties, but some things I think can be said. One is that, not surprisingly, the Roberts Court is a lot like the late Rehnquist Court. To date, only 2 members have changed, and Chief Justice Roberts, after all, a law clerk and tremendous admirer of Chief Justice Rehnquist, so it's hardly shocking that Chief Justice Roberts has not come in and changed the dynamic entirely. On a sort of advocate's perspective, however, there is one very noticeable change, and that is in the way that Chief Justice Roberts approaches oral argument as opposed to Chief Justice Rehnquist. Chief Justice Roberts is something of a unique individual in terms of at least the modern history of the court, which is, it's really been since Jackson, Justice Jackson, that you've had somebody with so much experience arguing before the Supreme Court. Yes, Justice Thurgood Marshall had a fair amount as well, but it's in the more recent history, you do not have lawyers on the court who've argued a great deal before the Supreme Court. Chief Justice Roberts is a veteran of some 38 arguments before the court, but I think for my purposes, in some respects, almost more interestingly, he is the veteran of many, many, many more moot courts. Moot courts, the process of preparing for oral argument, which I think is something that is a relatively recent phenomenon. The SG's office didn't do it until Ken Starr became the Solicitor General in the first Bush administration. So this is a relatively new phenomenon. Chief Justice Roberts is a veteran of many of these moot courts. And moot courts, even more than the real thing, are designed to find that one diabolical question that causes your whole theory of the case to unravel. Question for both sides of the case. And I think if you watch the Chief Justice in action, you can see this experience as a veteran of these moved courts. It certainly tends to ask more and more difficult questions to the side that he may ultimately vote against. But having been on that side and the other side myself, I can say that. But even when he's on your side, he will often ask you the one question you least wanted to be asked. And in that sense, I think he is a very formidable Chief Justice on the bench. This is not to say that Chief Justice Rehnquist was a pushover in his questioning, far from it. But Chief Justice Rehnquist, especially toward the end of his career, sort of, I think, took on a special view of his role as chief. And he was something of a traffic cop as well as Chief Justice. He told you when to move on to your second argument. He famously told lawyers, if you have a fallback argument, it's about time to fall back. Not words you were looking to hear, but helpful direction nonetheless. Chief Justice Roberts, by contrast, really approaches his job in questioning, I think, much the way that the Associate Justices approach the job. Not as traffic cop, but as there to figure out what your theory of the case is and whether or not it works at the end of the day. Another thing that can be said about the Roberts Court, which is fair to say, I think, is the importance of Justice Kennedy to the outcome in many of the hot-button issues. This is a court where it is often very easy when a client asks you, well, what's likely to happen in this particular hot-button case? Lawyers never like to answer those questions. The only thing they hate more is giving percentages of the outcome. But I found myself in a couple of cases being able to predict rather boldly that the court will decide the case 5-4 and that Justice Kennedy will be in the majority. Beyond that, I can't say anything useful. Like which side he'll be on, who else will be in the majority. But I can pretty confidently predict that it'll be a 5-4 decision that he will be in the majority. Now, I think that can be overstated because while I think that is true in many of the closely watched kind of hot-button issues, when you get beyond that part of the court's docket to the part where, maybe it's the part of the docket that only a lawyer could love, but the parts of the docket that have slightly less hot-button issues, there are often very interesting arrangements among the justices. A number of very important criminal procedure cases, for example, have been decided 5-4, where the 5 in the majority are Justice Stevens, Justice Scalia, Justice Thomas, Justice Souter, and Justice Ginsburg. Now that is an interesting array of justices. The justices in dissent include Justice Breyer, Justice Kennedy. They used to include Chief Justice Rehnquist and Justice O'Connor. They now often include Chief Justice Roberts and Justice Alito. So this is an interesting series of cases, and a very important one. I mean, again, if you get outside the realm of social issues and look at criminal procedure, and particularly the issue of the Sixth Amendment right to counsel, and how we go about sentencing criminals in this country, there's been an absolute revolution in criminal sentencing in the federal system over the last 5 to 7 years. And it has been one decision after another by these 5 justices. And it's an incredible collection of justices. My own view is that there actually is a way of understanding this, and in some respects, the 5 justices in the majority are those that are the most theoretical and least pragmatic of the 9 justices. And the 4 justices in dissent are the more pragmatic justices. And when you're engaged in an enterprise that essentially completely reconstructs the way that criminal sentencing has been done in the country for 25 years, you can see why the pragmatists would be a little more concerned about that reconstruction than those that are simply interested in getting the Sixth Amendment answer right in their own view. It's not to concede that they have the right view of the Sixth Amendment, since it's on the losing side of one of those cases too. But it is a very interesting phenomenon that I think is worth noting. I think it also points up another important fact that's particularly relevant today, which is, there's this certain tendency, I think, at least in Washington, to think that while this new nomination is very important, every Supreme Court justice is very important, every nomination process is very important, it may not change all that much. Because on many of these social issues, one assumes that if President Obama, unless President Obama has made a grave mistake, that Justice Sotomayor is going to approach many of these issues the way that Justice Souter did. But these cases, these criminal procedure cases, points out that Justice Souter is in the majority in these cases. They are 5-4 cases. They could come out the other way if Justice Souter had been in dissent, or if Judge Sotomayor, soon to be Justice Sotomayor, takes a different view of the issue. And it's not at all out of the realm of possibility. I can't say I was privy to the Obama administration vetting process for Supreme Court justices. But I'm going to go out on a limb and say they probably did not ask a lot of questions about the Apprendi line of Sixth Amendment cases and Judge Sotomayor's view of those cases. And Judge Sotomayor, one of her many qualifications to take on this new post, is that she's a former prosecutor. So she may well have a relatively pragmatic view of the sentencing issues. Now, given that we're sort of halfway through the process of reconstructing the criminal sentencing procedure, she may think that the best course is not the unreconstructed halfway. I'm not trying to predict her vote. But I think it underscores that on many, many issues, the justices are arrayed in very interesting ways. But nonetheless, in talking about the Roberts Court, it's very hard not to focus on the critical role that Justice Kennedy can play. Let me make two more observations before leaving a little time to take some questions about the Roberts Court. This one observation will, I think, illustrate something that's emerged about the Roberts Court, but also shows the difficulty of making bold statements about the Roberts Court based on what are, by any historical measure, very early returns. Predicting the Roberts Court based on 3 terms makes exit polling look like an exact science. And so, at the end of last term, and even more so at the end of the term before that, people who were court watchers, very sophisticated court watchers, were boldly proclaiming that the Roberts Court was a fundamentally pro-business court. One commentator said that they thought the Rehnquist Court was a pro-business court until they saw the Roberts Court. At the end of last term, where the court held in a couple of high-profile preemption cases about whether federal law preempts and crowds out state tort actions, one very well-respected commentator, whose name I'll protect, was boldly saying that the Roberts Court had never seen a plaintiff, essentially in these cases, that they liked, and that essentially they consistently ruled against the consumer and plaintiff interests and in favor of big business. Well, at the end of this term, the picture looks very, very different, much more complicated. The court this term had 3 high-profile cases involving preemption, where the federal law crowds out state tort suits. They came up in very different contexts. One was in cigarette advertising, one was in the context of pharmaceuticals, and one was in the context of the regulation of national banks. In each of those 3 cases, the pro-preemption side lost, and the consumers and the plaintiffs in those cases prevailed. And the last of those cases involving bank regulation, I should add, just to underscore that this is not always a 5-4 court with Kennedy controlling the outcome. It was a 5-4 decision in favor of preemption. The opinion was written and the critical vote cast by Justice Scalia, joined by Justice Stevens, Justice Souter, Justice Breyer, and Justice Ginsburg. So it does show that there are unusual alignments, but it also shows that saying that this is definitively a pro-business or pro-preemption court is a dangerous business. In the area of business law, though, there are still some things that one can say that are meaningful. I think you have to drill down a little further and look at a more specific topic. Take, for example, antitrust law. In the antitrust area, the Roberts Court has taken 7 cases, which is a decent number of cases. They've shown some interest in antitrust cases. In all 7 of those cases, the antitrust plaintiff lost and the antitrust defendant won. So I think that shows you a pretty clear trend. To make the trend even clearer, with one exception, these cases weren't even close. There's one case that was 5-4 that ended up being a division more about stare decisis than about antitrust law. In the other 6 cases, the antitrust plaintiffs got a total of 5 votes, total, across those cases. So these are not 5-4 cases where there's some economic conservative bare majority. These are 9-0, 8-1, 7-2 decisions in favor of the antitrust defendant against the antitrust plaintiff. Another area, I'll be brief, so I realize I'm on thin ice talking about patent law and mixed company. But let me say this about patent law. The Supreme Court of the United States, in the last 5 patent cases, has reversed the Federal Circuit, which is a court that was specifically designed to have specialized jurisdiction over the patent law, so be the patent law experts. They've reversed the Federal Circuit in 5 out of the last 5 cases. Even more starkly, though, in those 5 cases, the total cumulative vote was 43-2. So the patent experts at the Federal Circuit got exactly 2 votes in 5 cases. Now again, whether that's particularly interesting to you or not depends on whether the words patent law are sleep-inducing. But I really think the fact that the Supreme Court has gotten involved in patent cases and has been very skeptical of the Federal Circuit is a very important aspect of this court's jurisprudence. And I think it shows something about the Roberts Court, which is frankly, I think the Roberts Court, and certainly Chief Justice Roberts, who was an advocate and handled cases in the Federal Circuit, understands that in this day and age, intellectual property is essentially too important to the overall economy of this nation to leave it to a specialized court. The Supreme Court needs to weigh in on those issues. The last thing I'll say about the Roberts Court as an emerging trend is it does seem to me that if any one thing emerges clearly from the Roberts Court, the early Roberts Court, as an important trend that cuts across cases and subject matter areas, is that this is a court that is very hostile to facial challenges to statutes and has a strong preference for what are called as-applied challenges to statute. And that may seem like a lawyer's distinction, but it's a very important distinction. If you challenge a statute on its face, the entire statute is struck down, and because you're considering the statute essentially in the abstract, forces the court to consider hypothetical applications of the statute. As-applied challenges, on the other hand, focus specifically on the facts before the court in that case. And the court can look at the case in a concrete situation and decide whether the case before it is valid or not. If you think the distinction doesn't matter, let me use one area just to illustrate the point. Very early in my time in the Justice Department, I argued a case involving a child pornography statute. When those cases were coming through as applied challenges, something like 4 or 5 circuits that considered it, but every circuit court of appeals that considered the issue in an as-applied context, where they had a real defendant that engaged in real conduct involving real victims. In those situations, the courts ruled uniformly for the government and upheld the constitutionality of the statute. When one circuit considered the case in the context of a facial challenge, where you don't have a real defendant, where you don't have real materials that are in the record, the court said that the statute was unconstitutional. The Supreme Court reviewed that and found the statute unconstitutional. And I think, not to put too fine a point on it, but in this particular area, if you have a facial challenge, it's easy to imagine prosecutions that involve teenage actors in a recreation of Romeo and Juliet. When you have a particular defendant and particular images and a real record before you, that kind of hypothesizing is much less persuasive. And so these make real differences. And if you look at the decisions of the Roberts Court, again, across areas, from things like abortion notification statutes to voter ID requirements, which is a big issue before the court the term before last, to the death penalty and the use of lethal injection, some of the most important issues that the court has dealt with, it has often decided that it's going to reject a facial challenge and insist, not that the issue is over once and for all, but that insist, as Justice Kennedy put it in a 5-4 opinion for the court, showing his importance, that as-applied challenges are the basic building blocks of constitutional adjudication. They're the basic way this court wants to do business. And again, on these decisions, some of them have been 5-4, but some of them have also been 9-0, some of them have been 7-2. There's a pretty broad consensus, I think, on the Roberts Court that the way to go about constitutional adjudication is not on abstractions, but on specific cases involving real parties and interests. Well, those are my thoughts on the Roberts Court, my thoughts on Justice Jackson, what we can learn from him, and the special relationship between the Solicitor General's office and the court. I'd be happy to entertain a few questions if there are some.